We have also seen the ICC undermine domestic justice in numerous African states. Let me give an example that I talk about in the book. The very first cases opened by the ICC involved Ituri warlords from northeastern Congo, Thomas Lubanga, Jermaine Katanga, and Matthew Ngujolo. At the time that the ICC became involved in Ituri, those rebel leaders were already being investigated by the domestic court system in Congo. What was happening in Ituri was that the local courts had gone through an enormous reform process from 2003 onwards, funded by the European Commission, which had gotten a quite dormant and disorganized judicial system up to scratch. New personnel, new training, new legislative framework, and that system was now delivering justice. It already had a track record of dealing with middle-ranking and high-ranking members of the Congolese army. So on the ground in Bunia, where I was doing research at the time, there was an enormous amount of anger from local actors inside the Ituri judiciary about the fact that the ICC had stolen these cases from under their noses. They were saying things like, we've done what the international community wanted us to do. We've reformed our judiciary. And we're up to scratch. We can deal with these tough cases. But the minute we get the opportunity to deal with these high-profile cases in our own courtrooms, these individuals are now whisked off to The Hague. And we've seen similar dynamics in places like Cote d'Ivoire, Libya, and Uganda, where the domestic courts are not only capable, but in many respects actively willing to deal with high-profile suspects, and there's anger about the fact that the ICC is dealing with these cases instead. It's a different situation here in Kenya, I realize, because of the stillborn attempt to set up a special tribunal here. So I understand entirely that in many respects the judicial and the political environment here in Kenya are different. What I am pointing to is more what has happened in places like Uganda, Congo, Mali, CAR, Libya, where domestic courts are seeing their own initiatives, their own reforms undercut by the ICC's heavy desire to get cases underway and to get them underway in The Hague. And then finally, in all of this, what we've also seen the ICC do, I argue in the book, is limit the scope for creativity for African states and communities across the continent to determine on their own terms how they are going to deal with mass atrocities. Because the ICC insists on a prosecution at all costs approach. And again, this goes back to the idea of distance. If you are detached from the local context, you don't have to worry about local consequences. And so what comes out of my research, especially in places like Uganda and Congo, is that this heavy emphasis on absolutely having to criminally investigate and criminally prosecute means that societies now have less latitude to determine the best way to deal with the past. So, for example, what many African states are now being told by the ICC and its international backers is you cannot, under any circumstances, use conditional amnesties to deal with mass atrocity. Amnesty is now off the table. And this is proving to be heavily problematic in all sorts of mechanisms across Africa. It's making it tougher now to set up truth commissions that rely on amnesties, if those amnesties are going to be given to high-ranking suspects. The ICC says you can't do that. This is also a problem for security sector reform and DDR, because these are mechanisms that often involve tacitly or explicitly an amnesty. The ICC makes that more difficult. But the most acute problem is what we have witnessed during peace negotiations in various parts of Africa in the last 10 or 15 years. One of the key tools that many conflict mediators insist on is to keep amnesty, at least as a possibility, on the table when they are negotiating. They may not use it, but they need to be able to dangle it as an incentive, especially for rebel actors to consider putting down their arms. This was an enormous problem during the Juba peace talks between the Ugandan government and the LRA between 2006 and 2008. I spent a huge amount of time in Juba in northern Uganda, in New York, in London, talking to the whole range of actors involved in the Ugandan peace process. And they were all saying the same thing. We have almost no scope for maneuver in these negotiations because the ICC has already issued these arrest warrants for the top 5 commanders of the LRA. We can't get any traction with the rebels because they are justifiably saying to us, if we lay down our arms and we do a deal, the minute we walk away from these negotiations, we are going to be whisked off to The Hague and prosecuted by the ICC. So why would we agree to any of these terms? There are numerous reasons why the Juba process collapsed, but one of the key reasons was this threat of ICC sanction and the lack of flexibility, the lack of latitude for negotiators on the ground. We've seen the same thing recently in Colombia. This is not just an African problem. Look at the Colombian peace process. Coming out of the Havana talks, there was an attempt to give the FARC rebels something to incentivize them to end the civil war, but that peace deal also involves a certain creative approach to prosecutions with creative sentencing. It's a fascinating hybrid approach to transitional justice coming out of the Havana talks. It's a good faith agreement that is trying to deal with the different interests of the key parties. The minute the transitional justice mechanism was announced, the minute the parties walked out of Havana, there were 2 press statements from the Office of the Prosecutor of the ICC saying, we are skeptical of this institution. Human Rights Watch, Amnesty International, and several major donors of the ICC put out even more vociferous statements about the Colombian peace process, saying this is impunity. This, I think, was a fundamentalist position that completely ignored the very difficult negotiations, the good faith negotiations that have been going on in Colombia for years. The view was anything less than international investigation and international prosecution equals impunity. There is no flexibility. There is no other way to address the crimes of the past. I was just in South Africa. I launched my book in Cape Town and Pretoria. Unprompted at both events, there were members, former commissioners of the TRC in the audience. I'd never met these people before. I saw them, I didn't know who they were. They both put their hands up in the Q&A. And they said the thing that worries us about the ICC today is that we could never have had the transition that we had in South Africa in 1994 if we had been operating within this framework. Because we offered an amnesty as part of the TRC process. It was absolutely central to our transition from apartheid. And if we had threatened international or domestic prosecution of former elites from the apartheid regime, the transition would never have happened, and the danger is we would have had a civil war. We could not have had the South African transition in the context of the ICC. That is a major problem. And so what I argue in the book is that this lack of flexibility for states and societies to determine how to deal with their own particular conflict context, in fact, makes conflict more rather than less likely. So finally, I've been very critical in my presentation, and I'm very critical in the book. But in the conclusion to the book, I try to look forward to say, what do we do with all of this? How do we respond to the problems of distant justice and the problems that the ICC is producing, especially for African states? And I think there are 2 key responses, and I'm going to end on this. The first response is we need structural, deep reform of the ICC itself. One of the things that worries me at the moment, at a time of crisis, even within the ICC, is most of the prescriptions that are being given are extremely weak. They are tinkering, they are little technical tweaks of the Rome Statute in the belief that this will somehow make the ICC an effective investigator, an effective actor. It's not enough. We need some structural and profound reforms. And there are lots of things that I propose in the book. The ICC, to put it bluntly, needs to get out of The Hague, and it needs to get politically savvier if it's going to be effective. It's got to stop the kind of naivete that is also talked about in the 2 reports over here that I've already mentioned about how to navigate state power. The ICC needs stronger local officers. It can't continue to do the work from afar. It's got to have much more of a presence. It has to increase its political expertise. It has to hire Kenyan political and legal experts, for example, to guide its work on the ground in a way that the ICC never did when it intervened here in Kenya. The court also needs to build much more constructive relations with actors other than the executives of states, because that is the main set of relations that the ICC has built. The court needs to build relationships, for example, with opposition political parties and other political actors on the ground who can help it navigate the terrain. It needs to start to talk to domestic judiciaries. It's remarkable, given the language of complementarity, that the court has almost never systematically consulted domestic court systems, and it is preferred to deal with executives, particularly of African states. The court needs a better set of relations with UN peacekeeping missions and AU peacekeeping missions. It is remarkable how antagonistic those missions are also towards the ICC, because they feel that the ICC has often come in arrogantly and told them what to do. But peacekeeping missions can sometimes provide the enforcement mechanisms that domestic governments are unwilling to. Peacekeeping missions can be one of the court's best friends in terms of the arrest and the transfer of suspects from the battlefield to The Hague. But time and again, in Uganda, in Sudan, in Congo and elsewhere, peacekeeping mission officials have said to me, the court has never come here and spoken to us and seen how we can cooperate. It just expects that cooperation. So the court has to improve that. The court has to get smarter about investigations. It cannot only rely on eyewitness testimony. It has to find other ways of gathering evidence. And also, maybe we need a total rethink about the types of cases that the ICC is actually equipped to deal with. Maybe we ultimately have to say, whatever reforms you put in place, the court will never be able to deal with members of sitting governments. Maybe that is a tragic but truthful reality. In which case, cases involving rebel leaders and other non-state actors can be dealt with by domestic courts. The ICC, in many respects, shouldn't even be touching those cases. But there's another category of cases that the ICC has not dealt with yet that I think it can play an important role in, and that probably can't be dealt with by domestic courts. And those are cases that involve the background actors that make conflict possible, the financiers, transnationally, who support even the violence that took place here in Kenya, but that is a key part of violence across the African continent. Shadowy players, evidence of whom is often not solely located in that particular state. Evidence about these financiers and other orchestrators often leaves an international trail in bank accounts, in other diplomatic circles, and so therefore can be accessed by the ICC even if the domestic government tries to block them. And it's that transnational terrain where individual states probably can't play much of a role, but where the ICC can. Now, in the early days of his period as chief prosecutor, Ocampo flagged this. He in fact said the ICC might be able to play an important role in dealing with these kinds of transnational, especially financial and corporate crimes, but he never did it. I think there is potentially a role for the ICC in that respect. But the more important finding in the book, in terms of looking ahead, is that ultimately I think we have to be totally sober about how possible it is to reform the ICC. There is almost no interest inside the court for a structural reform process. I argue for it in the book, but I'm circumspect about how serious the court is about this. And so for that reason, what I argue is we need to fundamentally reorient our discussions towards domestic responses to mass atrocity. To a certain extent, I think we need to give up on the idea that the ICC somehow provides a remedy, that it somehow provides a form of justice that is superior to the domestic space. I understand why that hope was there in many parts of the world. But I think we now in 2019 have to admit to the fact the ICC is what it is, with all of its weaknesses, with all of its negative consequences on the ground. And so I think now we need a much deeper conversation about what domestic remedies in Africa look like. There is often a view, and I even heard it at the African Union when I was just in Addis a couple of days ago, African states aren't serious about dealing with their own atrocities. African states have no willpower to deal with genocide, war crimes, and crimes against humanity. Their courts are weak, their executives are too strong, it's not going to happen. There's an enormous amount of cynicism about the intransigence of African states, and I understand that. In the Kenyan case, the government here was incredibly cynical about arguing to the ICC that there was a domestic court process to try to claim jurisdiction when in fact there was nothing of the sort. So I understand the concerns. However, even here in the Kenyan case, what happened around the 2017 elections and the role of your Supreme Court in annulling the election result says that even in a situation like this, domestic judiciaries can start to change. They have limitations, they are not perfect. But the vetting of judges that had taken place in Kenya since the post-election violence emboldened and enabled even the court system here in a very antagonistic political environment to do one of the bravest things that a court system can do, which is to annul an election result that supports the incumbents. I've already mentioned the reform process in Ituri, where the military courts are now playing a much more robust role, and in many respects are dealing with tougher cases even than the ICC has in Congo, because the military courts in Ituri now are dealing with government cases, cases involving the Congolese army. We have seen numerous other examples across the continent. South Africa using universal jurisdiction to deal with crimes committed by Mugabe's regime in Zimbabwe. We've seen Rwanda use community-based courts to deal with genocide cases. We've seen the very creative approach around the Hissène Habré case in Senegal. A hybrid tribunal set up inside the Senegalese court system, mainly backed by the African Union, with African judges, African lawyers, delivering an incredibly robust form of accountability for a former African president. What this shows is, in various parts of the continent, there is already momentum and creativity around African states starting to deal with these cases on their own terms, rather than constantly looking to the ICC. And this is why I do think the AU's transitional justice policy, which has just been passed, lays a framework for this. It says to African states, stop looking for international rescue. Get serious about dealing with these cases on your own. And in many respects, I don't think we've even started to have a robust enough discussion about the need and the scope to reform domestic judiciaries in Africa and elsewhere. There's always been this assumption it's impossible to do that. These courts will never be able to deal with cases on their own. Why do we think that? Is it not time that we start to say, are there ways to reform judiciaries, even in very antagonistic political environments? And also, why do we think this has to only be about domestic courts? Accountability is not only delivered through courts. There are other mechanisms, there are other approaches. The Gambian Truth Commission at the moment is a fantastic example of a non-prosecutorial process that is delivering a high degree of accountability. It is finding and shaming high-level actors who now will have to be excluded from the political terrain because of the information that has come to light. Importantly, the Gambian Truth Commission has already presented evidence about the potential, and I emphasize the word potential, culpability, even of the current ICC prosecutor, Fatou Bensouda. There is an enormous debate going on in Gambia about how believable that evidence against Bensouda is, but it shows the robustness of that Truth Commission, that someone as powerful as the current ICC prosecutor is also being subjected to public scrutiny. And she will get her chance to respond, so we'll have to see how that plays out. The point here is domestic remedies are imperfect, but that's, I think, where our momentum needs to be now. The ICC, to a large extent, has failed and it will not reform. We have to change our focus. And I'm not romanticizing domestic remedies. I understand all of their problems. But they have inherent advantages over international intervention. These are institutions in African states that last. Court systems last, as opposed to the ICC that will come and go. And if they are constructed well, these are institutions that have presence amongst local communities. They can be observed, they can be participated in, and they potentially can be held accountable in the way that the very distant institution of the ICC simply cannot be. So my big message in the book is the court probably cannot be improved. Let's start to talk about domestic, and by that I mean national and community level responses to atrocities. I think that's where our focus now needs to be. Thank you very much.